Took a swing at a wrecking ball and I prayed for my downfall, and I found a way to reconcile, 'cause in my heart it's not worthwhile. It's a bloody battlefield where some go down, others heal. In the end it's all the same. All you can do is play the game. Oh, do we say goodbye? Refuse to question why. I'm sad to say I'm sorry, so lie. Pretend that you're okay. Swear that you will stay. Keep trying for one day. I'm sick of all these lies. Don't care if I capsize. There's nothing left for me to hide. Don't wanna live a lie. Too many lows, too many highs. Too many things to criticize. And so I leave it all behind. Don't wanna live a lie. Life kept spitting at my feet and forced me down a dead-end street, when all I had went up in flames, burning only dark remains. I cover up every part of my skin, oh, 'cause I don't like the person within. Oh, I know I'm the one to blame. All I can do is take the shame. Oh, do we say goodbye? Refuse to question why. I'm too sad to say I'm sorry, so lie and pretend that you're okay. Swear that you will stay. Keep trying for one day. Whoa, I'm sick of all these lies. Don't care if I capsize. There's nothing left for me to hide. Don't wanna live a lie. Too many lows, too many highs. Too many things to criticize. So I leave it all behind. Don't wanna live a lie. Sick of all these lies. Don't care if I capsize. Oh no. Took a swing at a wrecking ball and I prayed for my downfall, and I found a way to reconcile, 'cause in my heart it's not worthwhile. It's a bloody battlefield where some go down, others heal. In the end it's all the same. All you can do is play the game. Oh, do we say goodbye? Refuse to question why. I'm sad to say I'm sorry, so lie. Pretend that you're okay. Swear that you will stay. Keep trying for one day. I'm sick of all these lies. Don't care if I my feet and forced me down a dead-end street when all I had went up in flames, burning only dark remains. I cover up every part of my skin, oh, 'cause I don't like the person within, oh. I know I'm the one to blame. All I can do is take the shame, oh. Do we say goodbye? Refuse to question why. I'm too sad to say I'm sorry, so lie and pretend that you're okay. Swear that you will stay. Keep trying for one day. Whoa, I'm sick of all these lies. Don't care if I capsize. There's nothing left for me to hide. Don't wanna live a lie. Too many lows, too many highs, too many things to criticize. So I leave it all behind. Don't wanna live a lie. Sick of all these lies. Don't care if I capsize. Oh no. Took a swing at a wrecking ball and I prayed for my downfall, and I found a way to reconcile, 'cause in my heart it's not worthwhile. It's a bloody battlefield where some go down, others heal. In the end it's all the same. All you can do is play the game. Oh, do we say goodbye? Refuse to question why. I'm sad to say I'm sorry, so lie, pretend that you're okay. Swear that you will stay. Keep trying for one day. I'm sick of all these lies. Don't care if I capsize. There's nothing left for me to hide. Don't wanna live a lie. Too many lows, too many highs, too many things to criticize. And so I leave it all behind. Don't wanna live a lie. Life kept spitting at my feet and forced me down a dead-end street when all I had went up in flames, burning only dark remains. I cover up every part of my skin, oh, 'cause I don't like the person within, oh. I know I'm the one to blame. All I can do is take the shame, oh. Do we say goodbye? Refuse to question why. I'm too sad to say I'm sorry, so lie and pretend that you're okay. Swear that you will stay.
All right, guys. So we are going to start the PM stream, and get back to work here. So I looked just to see how long it was going to be. It's less than an hour. So it looks like I assume the state rests, and then there's probably maybe the directed verdict argument, where they're asking for directed acquittal. That's what I think. I don't know. We're going to find out. Anyways, let's jump into the courtroom. Let's get started without further ado and get through the rest of this day. So welcome to the PM session, guys. And then we'll be back to talk about this case and the whole day and everything in between. Let's go.
Welcome back, members of the jury. We're ready to resume with the examination of Dr. Welton.
Good afternoon, Doctor.
Good afternoon.
I don't have too many questions for you, but I do have a few.
Sure.
You testified earlier, I'd say it's this morning, but I think it was afternoon, but that you were not able to determine the time of death in this case?
The exact time, yes.
Okay. And I think in your report you also testified that that when you so you reviewed photos from the crime scene, is that fair to say?
At some point I probably did, yes.
Okay. And also during your examination, also you noted that Miss Avery's body was in a state of fully developed rigor mortis?
That is correct.
Okay, and that's a process that occurs after death, correct?
Yes.
And it's fair to say that that process, depending on variables, well, let me ask you this: what do you mean by fully developed?
So, fully developed, generally, it's kind of a loose concept in that if I try to move some of the larger muscle groups, they're not going to move.
Okay, and that process can take anywhere from like 24 to 36 hours?
It starts within hours after death, but becomes full 12 to 24.
Okay, and so when you... so it's fair to say that the condition of her body at the time you examined it and at the time of the photos was consistent with the time of death being sometime in the early morning hours of Saturday, January 12th.
That's a possibility, yes.
Okay. And you testified that you examined and was correct?
That is correct.
And it's true, however, that there's nothing about your examination that can tell you what order those wounds were incurred?
No.
And also that you can't, there's nothing about your examination that would allow you to opine about how quickly those things incurred, those wounds were incurred?
No.
I noted that you testified earlier that that perhaps the most significant wound was the one labeled N on her torso.
Yes.
And it was your testimony that that death would happen in that case in a matter of minutes.
Several minutes, yes.
Now, I just want to talk to you briefly about, you testified to some blunt force injuries?
Yes.
Those are essentially bruises in this case.
Bruises and scrapes.
Okay, and there was like one abrasion, is that fair to say?
I believe that was on the forehead, yes.
Okay. Now, it's also true that you can't necessarily tell in your examination how those wounds were incurred?
In this case, no.
Okay. And it's also possible that those wounds, even if they were incurred at the time of her death, were the result of falling after her injuries?
That is possible.
Okay. And it's also possible that those bruises were totally unrelated?
Yes.
Okay. And just one last question for you. The blunt force injuries, the bruises that you testified about, those were based in part on discoloration, is that fair to say?
For the most part, yes.
Okay, but the jury also saw some potential, or saw some photos, and maybe asked to look closer at some photos that showed some other discoloration of her body. Is that correct?
I believe so, yes.
Okay, and so my only question for you is that's a product, that discoloration, if it's not the wounds that you noted, is a product of livor mortis, isn't that correct?
It could be, yes.
Okay. Specifically discoloration on her back?
Yes.
And that's from the blood pooling while she's on her back?
That's correct.
Okay. No further questions?
May you redirect, Mr. Green?
No, thank you.
All right, thank you very much, Doctor.
You're welcome.
Your Honor, I believe previous O for ID, would like to submit now as an exhibit. I don't know what we're up to.
83,
if there's no
the
objection.
redacted version of O for ID.
Yes.
Members of the jury, remember what I told you about redactions. You're not to speculate about what's not in there. It's simply not evidence. It's out for evidentiary reasons that don't concern you.
And with that, the Commonwealth would rest.
Commonwealth rests.
May we approach
Take to be seen, please. Yeah.
So the state has rested finally, just as I thought they would. So we'll see what happens next here, and see if they address whether or not Mr. Scanlon will be taking the stand or not. So let's see what unfolds and transpires.
Mazza, recalled.
Yes, I would recall at this time Detective Mazza.
Detective Mazza, recalled.
Jurors, you're in one more time, sir. Do you solemnly swear that the evidence you will give this court and jury in the case that's now on trial shall be the truth, the whole truth, and nothing but the truth, so help you God? Sir. Thank you. Please resume the stand.
Thank you, Detective Mazza, for sticking with us just a little bit longer. May I approach?
Yes, free approach.
Do you recognize what that is?
Yes.
Okay, what can you tell the jury what you're looking at?
It'll be a map quest, or some sort of picture of a map of North Elm Street, like pretty much downtown, the bridges in Westfield.
Okay, and you're a Westfield police officer, so you're very familiar with Westfield?
Yes.
And that particular part of Westfield?
Yes.
I'm going to give you a pen. If you could just indicate on there where the width is. And do you see the address on White Street that we've been talking about? And let me ask you. Does that look like the accurate placement for the address on White Street?
It does.
Okay. Could you just circle that? All right. And now that, if you could just quickly, using that pen, if you could just mark the route that you testified to When you testified yesterday? It is a little hard to see. I can appreciate that. Now, you testified yesterday that you, as a part of the investigation, went to the Westfield Soup Kitchen to obtain, to see if they had any relevant videos. Is that correct?
Correct.
And do you see where the location of the Westfield Soup Kitchen is on there?
Yeah.
Can you circle that?
Yep.
Can we mark the individual spots a little differently? Maybe W for whip or S for soup? Or
Sure,
something, just
that'd
so
be
we can
great.
kind of
Put an H for house and S for the soup kitchen.
okay.
Okay. And just to, and I'll put this up in just a minute, but the whip is actually written, is on the
this
map
labeled
to
on the
begin
map.
with.
Okay, thank you.
And so you marked the location of the soup kitchen, correct?
Correct.
Okay. May I display this, Your Honor?
It's not an exhibit yet. Did we mark? We didn't mark it yet, did we?
No objection.
All right, so we'll mark it as an exhibit
Okay.
without objection.
54.
84.
And if it would be okay with Your Honor, if Detective, if you might stand at that screen and just, it's marked on the pen, but if you could just with your finger or the pen that's there, show the jury the route that you testified to yesterday.
We may have a pointer. Let's just. We may have one. Old-fashioned pointer. No, not in this courtroom.
So actually, let me back up first. So now that you've circled those things, can you show the jury where the whip is on that map?
287.
Okay. And
Sorry to interrupt. You need to keep your voice up if you're going to be standing over there. You are picked up.
That's 287 North Elm Street.
Yeah, that's the width.
And can you show the jury where on the map 92 White Street is?
92 White Street is here, the H with circles.
Okay. And can you show the jury where you indicated the soup kitchen?
So the kitchen is marked by S, but it's right at the corner of White Street.
Okay. So fair to say, when anybody reaches that point, they are just moments away from that address at 92 White
It's
Street.
very, very close to 92 White Street.
Okay. And now just with you've indicated it in pen, but can you now just trace the route that you testified is the most direct route?
Sure. So North Elm Street south onto North Elm Street towards the Great River Bridge south. You cross the Great River Bridge south here. Avery Street is this street here. There's a little turnaround heading north on Elm Street. And you'll be heading east on Meadow Street to White Street, and then you get south towards White Street.
Okay, thank you. You can see.
You can just attach the mic back towards you. Thank you.
Yesterday you testified a little bit about those videos that you said that you obtained, correct?
Correct.
And you had an opportunity, I believe, today or this morning to review those videos again with the district attorney. Is that
Correct.
And you understand that Oh, thanks. These videos were preserved and given to the DA's office, correct?
Yes, correct.
And you had an opportunity to review them.
I did.
Before we look at those videos, I just have a couple more questions for you. Showing you 3 pictures from Google Maps. Do you recognize what those are?
I do.
And what is that?
One is a picture directly in front of 101 Meadow Street. One is a picture on White Street, but of the same building, 101 Meadow Street. And one is of the driveway for 101 Meadow Street. I believe the camera's right here in that photograph.
Okay.
Or one of them, at least.
Great. Can you circle that? Just maybe light camera.
That's it. Oh, that's what you'll be able to see.
I'd offer these as exhibit.
No objection.
Objection.
However you wish, Martin.
Okay, the next couple of exhibits. What is there, 3 of them there?
3, yeah.
3, yes.
3 of them. Your second exhibits, please.
All right, so there'll be 85, 86, and 87.
Oh, yes.
So I'm going to have my colleague play. Actually, I'd offer at this time the videos, the jump drive, as an exhibit as well.
All right. Any objection?
No, Your Honor.
All right, they may be marked. The flash drive itself will be marked in total as the next exhibit.
That will be 88.
Members of the jury, when you get the case to deliberate, we will provide for you a laptop, if you will, to be able to look at any of the digital evidence that you choose to look at that time, okay?
Detective, do you recognize, this is just the beginning of one of those videos, do you recognize what this depicts?
I do.
And what is that?
That'd be the front camera at 101 Meadow Street, and it's on Meadow Street.
Okay, and that's the soup kitchen, correct? And I note on there that there is a timestamp.
There is.
Okay. Now, as part of your job, it's routine for you to look and see if area businesses or anything like that might have video that is relevant to a crime you're investigating. Is that fair to say?
Correct.
Okay. And as part of that job, you would make a note if the business owner who controlled that camera told you anything about a timestamp being inaccurate, correct?
Correct.
Okay. And you specifically asked for video within the range of, I believe it was midnight and 2 o'clock?
Correct.
And you received more than just this 30 seconds of video, is that fair to say?
I believe I got a small handful of videos.
Okay. And you, from the videos that you received, clipped videos that you thought were relevant, is that fair to say?
Correct.
And what stood out to you as relevant in the video that we're about to see is that it shows a small dark-colored car that you believe was consistent with the car that with the Chevy Cobalt. Is that fair to say?
I believe so.
Okay. And in fact, in one of the videos, you indicated in your report that you believed you saw a passenger with a pink-colored top on. Is that fair to say?
Correct.
Okay. Is that fair and accurate?
Yes, it is.
Okay. And play the videos 25. Play, yeah. And video 27. Now, those are all sort of successive videos of that car that you believe was consistent with the Chevy Cobalt turning right from Meadow onto White. Is that correct?
Correct.
Okay. And if you can go to the timestamp we discussed. Oops. And when you wrote in your report that you believed you saw a passenger with pink video, is this the image that you were?
Correct.
Correct.
Yep.
Okay. And that's why you identified these as relevant.
Correct.
And preserved them for the investigation.
Correct.
I have no further questions.
Mr. Green?
Were you able to see a license plate in any of those videos for that vehicle?
No, sir, I was not.
Were you able to, at any point in time, confirm exactly who was in that car?
No, I did not.
And as far as the timestamp on the videos go, did you go down to the soup kitchen and look at your phone and the thing and say, aha, yes, they're exactly right?
I did not.
So you're just making a...
Objection, Your Honor.
Sustained.
So let me ask you this. How do you know that those timestamps are accurate?
Objection, Your Honor.
That's overruled.
I don't.
Anything further?
This camera these cameras were on private property, is that correct?
Correct.
So in order to get these, you have to go and talk to whoever controls the property and say, hey, we're looking for this video, do you have anything? Is that fair to say?
Yes.
Okay, and it's very much the case that that in other cases, sometimes the timestamp is off. Is that fair to say?
It is.
And if you discover that at the time, you would make a note of it in your report, correct?
Yes.
And it's often the case that whoever owns that property and runs that camera will let you know, hey, the timestamp is off. Is that fair to say?
Yes.
Okay. And you wrote a report in this case?
I did.
Right? And you didn't make any note whatsoever, correct?
I did not.
All right. So sitting here today, you don't have any information that that timestamp is incorrect.
I do not.
Thank you very much, Detective Mauser.
Yes, sir.
Anything further?
Nothing further, Your Honor.
Defense rests. The evidence is closed. All right, so if you put your notebooks down, we're going to send you home for the night because I have some matters to discuss with the lawyers. We're going to have the closing arguments and legal charge tomorrow morning. So, the first instruction I'll remind you is easy. The evidence is closed, but the closing arguments in this case are going to be very helpful to you, and you don't have the law yet. So keep an open mind until that occurs. And until I tell you to start your deliberations. As you well know, you're to decide this case based only on the evidence that we've all seen and heard in this courtroom during the course of these 2 days of trial, yesterday and today. That means that throughout the entire course of the trial until the verdict is reached, you must not search the internet, website, blogs, or use any other electronic tools to obtain any information about this case, conduct any legal research, or do anything else to help you decide the case. Do not try to find any information of any kind whatsoever about this case or any aspect of this case or information pertaining to this case outside of this courtroom. Do not investigate the matter. That includes do not take any views or do not take yourself to the area or in question to try to avail yourself of any information in that regard. Don't discuss the case with anybody, even among your fellow jurors. You'll have plenty of time when you deliberate to do that tomorrow. And don't discuss this case with anybody else until you've returned a verdict at the end of this particular case. If you see people involved in this case in the hallways, as you well know, avoid them. I know the court officers are showing you kind of the back stairs out of the building so that at least leaving the building you can avoid people in the hallways. But don't linger in the hallways when you come here tomorrow morning. Go right to the designated place that the court officers have provided for you to gather up and be brought back to the jury room. Do not seek out, read, watch, or listen to any aspect of this case that may appear on any media outlet, whether it be newspapers, television, the internet, blogs, whatever have you. And as you know, the reasons for this are simple but vitally important. You have all heard and seen the exact same evidence at the exact same time, along with all of us in this courtroom. And so getting any information, opinions, solicited or unsolicited about this case outside the four walls of this courtroom would be completely inappropriate and would cause major issues for the case. So we'll see you here tomorrow morning. Why don't you come just a little before 9? I hope to get to you as close to 9 as we possibly can, and then we'll have the closing arguments in charge, but the lawyers and I have some things to work on to get this case ready for you tomorrow. The one last thing I can tell you is that when you're deliberating tomorrow, if you're deliberating over the lunch hour, the Commonwealth very generously provides you with a lunch. So the court officers will take your lunch order at some point in time so that you won't have to interrupt your jury deliberations to leave the building for lunch. So you can plan on that, all of you. So we'll see you tomorrow. Get a good night's sleep. You have your work cut out for you tomorrow.
Cheers. Hearing anything, all rise.
Will have considered the defendant to have filed the oral motion at the conclusion of all the evidence to protect the record, which is also denied. Your rights are reserved, okay? So let's have a discussion. I don't have any requests for jury instructions, but I don't think there's going to be anything unusual with the exception of this issue of the voluntary manslaughter.
Yes, and the Commonwealth would also request a consciousness of guilt.
I have that in there. I may have a pretty decent working draft that's out of format, but it will be formatted by the time I get it in your hands. So let's talk about the voluntary manslaughter instruction. You're asking for that, right?
Yes.
Okay. Tell me under these facts how you think it applies, or why you think it applies.
Yeah, and I have a memo that lays this out as well.
It would be helpful to have it.
Submit.
Yeah.
But I was working on it during lunch, so I can print that out.
Okay.
For Your Honor. Thank you. I'm going to go through here. So, first of all, just looking at the burden. Defendant is entitled to a manslaughter instruction if any view of the evidence would permit a verdict of manslaughter, and the facts are to be taken in the light most favorable to Mr. Scanlon.
So tell me what facts we heard that you think in the light most favorable to Mr. Scanlon would entitle him to that instruction.
Right. So, first of all, he witnessed this contact between Ms. Avery and Mr. Burns. That is recognized in the law as something that can cause reasonable provocation. This is in my memo, but I would just point the court to a case called Commonwealth versus Valentin, which discusses kind of the nature of the relationship between the parties that you would need to allow for this type of contact to be sufficiently provoking. And one of the pieces of that is...
Give me the set on that.
Sure. It's 747 Mass 301. It's a 2016 case.
301, okay.
And In that case, it focuses in on the defendant's reasonable expectation if the person that he's dating or that he's still dating, if he has a reasonable expectation that she would not become romantically involved with other people.
So tell me why. You got a couple things there. You have one, that they're dating. On what view of the evidence was the defendant and Alexis dating?
So we heard some
at the time, at that day,
yeah,
right?
I'm going to start earlier, but I'm going to get there. So we had evidence that their relationship was on and off, that they reconciled many times. We had some evidence that they had, I promise, we had some evidence that that Ms. Avery had expressed an intention to break up on January 1st. We also had evidence that they continued living together, they continued parenting their child together, that...
There was no evidence on and off after January 1st. There was a history of the relationship being on and off, right?
That's right.
Okay.
That's right. We don't know what they talked about during that time. Ms. Avery had a Facebook account where she still listed that she was in a relationship with Mr. Scanlon.
No evidence that he knew about that.
No evidence that he knew about that.
Right.
But it could provide evidence as to how she was acting toward him. I think there's a reasonable inference from that.
Okay.
And in the light most favorable to Mr. Scanlon, I think you have to make that inference, actually. So these facts are taken in the light most favorable to Mr. Scanlon. And I would point out...
There was not even really any evidence as to when that separate Facebook was created, but...
But there was evidence that it existed, at least in the time after, shortly after she was...
How is it a reasonable inference that he would have seen her Facebook? There was no evidence that he was...
So I'm not making an inference that Mr. Scanlon saw her Facebook.
Okay.
I'm making an inference...
You're making the argument that because she left one of her Facebook accounts in a relationship that it suggests what she may have said and done with him between January 1st and...
Yeah, there was continued ambiguity. If you have people who were on and off, she may have made a statement on January 1st that she intended to break up with him, but they're still living together, they're still parenting their child.
There's the conversation on the 1st, right? And then there's the text, which I think was January 10th, right? That he wrote to her.
Right.
Right? So it would have to be something after January 10th that would lead him to have some reasonable expectation that the relationship was still ongoing, because that was not...
I don't think the state of the law is that there's an expectation that the relationship is ongoing. I think it's the reasonable expectation that this wouldn't be occurring yet. And
is that the law?
I would point the court to Valentin.
The issue is...
So on this point, I would point the court to Valentin, and it is far less clear than relationship versus no relationship.
And the question is not her conduct at all. The question is what would the effect be on him under the circumstances? And I would suggest here that they have a home together. It's clear they have a home together. If there was any discussion of him moving out, it was not happening yet. There's evidence that they were still continuing to share a very small apartment and in fact a bedroom. And that was still the case.
There's
on that
no
day.
evidence in the case that they shared a bedroom. There was no testimony or evidence in the case that they shared a bedroom. In the light most favorable to your client, there's evidence that they lived together in that spot.
And a two-bedroom apartment, only one of which had an adult bed. I think that's shown in the pictures and in the testimony. So the issue here is in the light most favorable. Is the provocation, is the emotional upset in the moment about whether or not that would have happened under those circumstances at that time, given their relationship? Not that
there's a lot of cases that talk about that this wasn't of course he caught them having sex in the back of the car, and that was a sudden event, right? We'll talk in a quick few moments about the fact that it was a private vehicle and he entered it without authority, which is, I'm not sure what the crime is, but I'm sure it's a crime. But so, and I'm not sure that matters to the analysis, but he knew, the state of the evidence is that he knew he was not invited to go out based upon the testimony of Mr.
happens, you can argue that he did not show up at the Maple Leaf because he didn't remember him being there. So I guess so he followed them at least to whip, and the testimony was that he saw them being romantically involved at the time, and said, if he keeps doing that, I'm going to F him up, right? So it's not. There's cases that talk about the fact that a defendant who had knowledge of infidelity, and we'll kind of put that aside for the moment, infidelity, he's not entitled to the shock of seeing kind of the logical extension of that. There's some pretty good case law on that. So tell me about that. I mean, that's the state of the evidence, that he knew she was with somebody.
He saw that night, although that's part of, I would argue, under the circumstances and the current state of the relationship, part of the provocation, and then knowing that he was there and that him seeing that, and here's the thing. The question isn't whether or not this defense is...
No, I get it. There's any reasonable view of the evidence, but I struggle on I listen hard for any reasonable view of the evidence to support that. So that's why I'm having this conversation, just to try to figure out.
Right. I mean, I think the bottom line is that within... so the timeline is that there was the discovery. Mr. Burns ordered the Uber at 1:19 a.m. according to the Uber records. We have video of them being literally seconds away from home by 1:21.
He said he waited till they left, so it's minutes. I mean, under any scenario, it's minutes, but between whip and there, okay.
And the question of cooling off is certainly a fact one for the jury. Under the circumstances, though, that in the light most favorable to Mr.
Yeah, there's some
Scanlon,
good law for you on cooling off. I think one of them was like 7 hours.
It is, Andrade.
So I'm not concerned about the cooling off piece.
Right. In which case, then we're just left with whether or not this pretty, criminal law textbook aspect, version of this discovery is, he ought to have the benefit of this instruction. And I would suggest that it's of constitutional due process, proportions.
The SJC just got rid of it for oral disclosure, so it's not quite that. So let's talk about where we stand after this case, Rocky.
Can I talk about Rocky? Can I just point the court to one more case for your consideration, which is Escobar, the case that came out last week, is, I would say, very supportive of Mr. Scanlon's position in terms of the...
There was evidence in Escobar that the fight continued into the alley, right?
There was some evidence of that.
That's why the SJC said...
But very, very thin evidence of that.
Right, but what evidence do we have here of kind of some ongoing shock?
Well,
It's different. Escobar's...
It's different.
Yeah.
We do have some evidence from Mr. Burns of as they were leaving the car, some argumentative speech.
And
In the parking lot.
Yes.
And her statement that she didn't want to be with him, she wanted to be with this other guy. And I would argue that is, in the light most favorable to the Commonwealth, is, to us, and the defendant, to extend that period. And again, that's a question of fact. If I can address Ronki for just a moment.
Yeah, we're going to talk about that.
That of course is an interesting and relevant case. It is very clear that the court has very firmly said that a oral disclosure or discovery of infidelity is not sufficient. It is, and I know Justice Cypher's concurrence in that case. However, until the SJC has clearly overruled this clear iteration of manslaughter, that it's a constitutional due process right to present a defense.
Well, you have a right to present a defense if it's a legally recognized defense. So if it was an oral disclosure here, you would have no right to present this defense.
I agree.
So, I mean, the case says the exception, which they are eliminating, rests on shaky misogynistic foundation that has no place in our modern jurisprudence. What's the difference between an oral disclosure and seeing somebody in the back of a car having sex?
That is,
Why wouldn't this SJC, because they didn't read, I'm sorry, I'm just talking out loud to try to think this through, okay? The SJC did not reach this issue that we have here in that case because they didn't have the facts. The facts weren't what we have here, so as you know, appellate courts don't reach farther than they have to. So they had an oral here and they left for some other day this particular issue. I'm sure that the Commonwealth's going to tell me this is the case, and I want to hear from you why it's not.
right, and you're correct, they don't reach farther than they have to. And since they have not, it remains good law, and that's where you get into the constitutional right to present a defense. Until and unless it is struck down, it is available. And in the light most common to the defendant, it remains the standard. Even if, Your Honor, it is very much the case that even if Your Honor gives this, the SJC may reach this on the merits, depending on how this turns out anyway, even if you give it. But until and unless the SJC, and that concurrence is interesting because it very specifically says we don't reach this issue.
Because they don't do that when they don't have the facts. They don't. Appellate courts don't reach issues that aren't presented to them. They address the facts in the case that they have. So they just left it open to plop down here in the courtroom for me to make a call. I mean,
well, and I would suggest to you that, I think, and maybe it's a little bit of speculation on my part, but if the result, if you were to not give the instruction, that it still would be a constitutional deprivation. It is possible that the SJC were to find a constitutional violation, give them a new trial, and in the process then strike down explicitly this defense or this mitigation. But it is not for the trial court to take off the books an existing defense that's still within the law. Especially when the case that you're relying on and looking at very clearly says
trial courts have to make the call every day, every courtroom, on what the SJC means in this case and how does it apply to this case. So I haven't decided yet, but I'm not. The facts of this case aren't. On this case, I'm not sure that the SJC wouldn't agree with me if I don't give the instruction. But tell me why. I want to fully air this out so that we all at least have a record.
I think because the standard is in the light most favorable to the defendant, and there is evidence, and it doesn't have to be much, but that there was, an ongoing relationship, they were co-parenting, they were sharing a home, and that there were expectations about how being confronted with that activity in that circumstance would affect Mr. Scanlon in that circumstance, and that's the standard. Is in the light most favorable. Is the provocation reasonable under the circumstances? Now, in not giving the instruction, that's saying as a matter of law it's not, and I'm suggesting that it is a jury question.
Okay. Who wants to handle this for the Commonwealth? I'll come back to you. If there's anything else we need to cover, we can cover it, but...
May I approach with a memo?
Yeah, sure.
Your Honor, so I think we start with the facts that have been proven in this case, and we go from there. And
not proven, just the light most favorable to the defendant, right?
Yes. Okay. So the evidence, in the world of evidence before the court, this jury could infer the following facts. That on January 10th, Friday, we start January 1st, Caitlin Avery is present during a conversation between Mr. Scanlon and Alexis Avery in which she says, I don't want to be with you anymore. That's January 1st.
Right.
On January 10th, the defendant, if you believe the text messages, acknowledges the fact that their relationship is over and says, can we just still love and raise Darla together?
Right.
So again, from the 1st to the 10th, There's no indication that this relationship was somehow rekindled or changed in any event.
I agree with you. There's nothing in between, there's no evidence between those two dates at all. It's empty. I'm not even sure there's an inference to be drawn by the fact that there's a Facebook indicating they were still in a relationship that somehow informs how she was acting toward him. I'm not sure that's...
I'm not sure it matters how Ms. Avery was acting towards the defendant. It was his state of mind that's relevant. So then we go to the evening of this incident.
Well, whether he had any reason to believe that the relationship was in some limbo status and not 100% over. That's their argument. I'm not arguing with you. Now I'm doing to you what I did to them. I want to hear you out.
And I think that it's the evidence is quite clear that this wasn't in limbo. There was a direct conversation on the 1st. That conversation was confirmed by the defendant on the 10th. And then if you recall the testimony of Caitlin Avery on the 11th, as they're getting ready to go out for their girls' night, she testified that the defendant is moping around the house saying, "I can't believe my family's leaving me." So again, from the 1st to the 10th, and even on the night of this incident, all of the evidence suggests that this defendant knows his relationship is over with Alexis Avery. The fact that they may still have shared the same residence, I don't think really moves the needle. This defendant's state of mind is what is the key issue. And from January 1st to the 10th to the 11th, by his own words, he knows this relationship is over. And then we get to whether or not this was some sort of sudden revelation of infidelity. First of all, I don't think you can have infidelity if you're not together. So that's point one. But the second thing I would suggest to the court is that Mr. Scanlon didn't just happen upon these two individuals and see something alarming and shocking. He, and the evidence may suggest, sought out Alexis Avery that night to see what she was doing. And at the Maple Leaf, there was testimony from Caitlin that Scott and Alexis were making out at the bar and the defendant was there. And
yeah, you're stuck with Burns' testimony, though, that he didn't see the guy there. He
doesn't know him. Well, yes, but we have...
The jury's free to accept that as he wasn't there. It's thin, but it's there. So
I agree, but I would suggest that the more credible testimony is from...
Can't do credibility today.
Caitlin Avery had a conversation with this defendant at the Maple Leaf. That's what she testified to. That puts him there. So again, the fact that Scott Burns, who has never met this guy before in his life, didn't see him there is irrelevant as to what Mr. Scanlon thought. The question is,
you're gonna have to live with what Burns said. I mean, I'm viewing the. You can argue to the jury.
I understand. I don't think it's living with what he said. He just didn't. He said he didn't remember him.
For purposes of today's discussion about where the defendant was in the light most favorable to the defendant, you have to accept that.
He said he didn't remember seeing him there, but he also said he'd never met him before.
Okay.
But Caitlin Avery's testimony, again, that's a credibility thing.
Yeah.
She knows Blake Scanlon. She's known him for years, and she said he was there. Mm-hmm. And that Alexis and Mr. Burns were being very open about their display of affection. So, if a fact finder were to believe that, which I think is certainly possible, likely, then we have information that the defendant then follows somehow. He wasn't told where they were going. He then ends up at the exact same next place where, and again, the testimony was...
The best you can do is that I'm just saying in the light most favorable to the defendant. I don't need your memos or even your instructions.
And actually, he said that didn't really notice raised voices. He agreed with one of defense's characterizations as, could it have been argumentative? And he said, possibly. But again, this wasn't a heated verbal exchange at the scene of this sudden revelation.
Would it be a fair inference that their argument continued on the way home for the 2 or 3 minutes it took?
I don't know. Every couple's different, every situation's different. I don't think that's a fair inference.
Okay.
I mean, they drove home, however long that took. We agree it's a short ride, but they went from one place to another. I don't think we can infer what was said in that car. They could have sat in silence. They could have argued. Again, that's purely, wildly speculative. All we know is that nothing happened in the parking lot and something happened at the apartment. When you add all of that up, there's no sudden revelation of infidelity. They were broken up. They'd been broken up for almost 2 weeks. He acknowledged it himself in text messages and in his statements before they went out that night without him. I think the defense has a very tough hill to climb to get to evidence that would even remotely suggest that this is a warranted instruction in light of these specific facts. And as far as the cases go, the memo that we've submitted also cites Valentin, and that's a particularly important case. In that case, and I think the site was wrong that counsel gave you, it's 474 Mass 301, but in any event, it's cited in the memo. In that case, the court found that there was no reasonable provocation where the victim and defendant's relationship had ended several hours prior to the shooting. Hours. This relationship ended weeks prior to this event. So I think that the cases are in line with the facts of this particular matter that do not warrant a manslaughter instruction under these facts for these jurors.
Okay. All right, is there anything else you want to talk to me about in terms of jury instructions other than the standard instructions?
Yes. So I think we're going to have requests for mental impairment instruction as to first degree and second degree intent, both on voluntary...
Not mental impairment, you're talking about alcohol.
No, both. Mental impairment based on Mr. Scanlon's suicide attempts following the killing, and then also on intoxication.
Not giving you the mental impairment. All right. Alcohol, yes. There's some evidence of that.
So we have that, and then for Your Honor's consideration in my memo, I have a involuntary manslaughter instruction, and I would cite the court to Commonwealth versus Gray, which is a 1987 case, which states that if you have a mental impairment instruction, a voluntary or a manslaughter instruction is warranted. And I think in that case it would be an involuntary manslaughter instruction, so I would submit that to the court for your consideration.
What is the case again?
It's Commonwealth versus Gray. I can give you the site.
Greg?
Gray, as in the color, but spelled with an E. Gray is 399, Mass 469. And the pin site is 474.
What does that case say, you say? What do you tell me?
What that case says is that where a mental impairment instruction is warranted, so too is a manslaughter instruction. It's specifically about mitigating second degree intent in that case. Mental impairment mitigating
voluntary manslaughter instruction you're talking about, or a voluntary manslaughter.
So, I mean, if you look at the model instructions, there's really no accommodation for this particular problem. So I think I believe it's an involuntary manslaughter instruction at that point. None of the voluntary manslaughter instructions really go with mental impairment. And what the case says is that where you're mitigating the specific...
Like, you have someone stabbed 28 times.
Yes.
So tell me how you can get an involuntary manslaughter instruction.
Just specifically from this case. It says that it mitigates murderous intent. And I think that mitigates down to involuntary manslaughter. I guess alternatively, I would suggest to the court that you say that to the extent that the jury finds that second degree intent is impaired, they can return a verdict of manslaughter.
And if I could just be heard briefly on intoxication defense.
I had it in the draft, Mr. Green.
I understand. I just want to just state the obvious. There was only evidence that sometime before 8 o'clock that night, the defendant took a few swigs of alcohol. And then Caitlin Avery specifically said, I did not see him drink again the rest of the night. And she said that she had been with him in the past when he was intoxicated, that he was not intoxicated, in her opinion, in this case, at that later hour at the bar.
The testimony about him taking 4 or 5 swigs or gulps or sip, whatever it was,
That was at 8 o'clock at night. Before 8. We knew he left at 8. So even if, and again, we don't know when this murder occurred, but we know that the defendant encountered the victim and Mr. Burns in his truck sometime around 1 a.m. That's 5 hours later with no other evidence at all that he was drinking or impaired. It's speculative at this point to even suggest that the defendant was under the influence.
what else do you have?
Just two things. One, again, we're in the light most favorable to the,
I'm with you.
it's always a fair inference that people are drinking in a bar. I think that's always a fair inference in the absence of one witness, not seeing a person drink is not evidence that no alcohol consumption occurred, especially when, her testimony was, along the lines of, taking these big swigs and indicating that Mr. Scanlon was drinking that night. So I'm not suggesting that it is an enormous amount of evidence, but it is enough to justify and to require the
Well, it's in there now. Anything else in particular?
No.
You want to get me whatever request you have or whatever memo you have in whatever shape it's in, frankly. All right. All right. So I'll see you at 9. Anything else? Word? Oh yeah, in Word would be good. No, I don't need it in Word. I have the instruction. I don't need your memos or even your instructions in Word. I have them all. I mean, I have the voluntary manslaughter in the instruction as a placeholder just now, but I want to hear from you.
In order to prepare closing.
How much time you need?
As much as you can give me, Your Honor. I mean, it'll be a very dramatically different closing.
Well, it's a half an hour, right? You don't need more than 45 minutes, do you?
Oh, in terms of time?
Yeah.
Oh, no, I don't think I'm going to need that much time. I meant in terms of knowing in advance whether or not we were getting the instructions.
Oh. Well, I can't tell you that right this moment, but I'll let Mr. Walsh know. He'll let you know, okay?
Okay, thank you. I'll be checking my email, of course.
He works around the clock. That's his reputation. Anything else?
No.
All right. Yeah, I'm stepping off. I'm going stepping off.
All rise.
All right, guys. So there we have it. The case has concluded against Blake Scanlon in 2 days. Now, we just heard some very important arguments and some very important cases because what they're arguing over, just to clarify there, what they're arguing over is whether or not the defense is entitled to a voluntary manslaughter instruction in regards to two factors. One, the heat of passion. And what they're saying is I guess he would be entitled to that if he was in a relationship with her. In other words, if he was married to her, number one, or number two, if they were still in an understood relationship. That's why the state was putting on the evidence, I guess, of saying that she ended the relationship back on January 1st. Now, the defense was relying on a case, the case that they were citing, which again, I wasn't impressed with the attorney's arguments there, because I mean, she's got this case she's relying on, and she seemed to be intimidated in her attempt at trying to explain the reason why she felt that case was relevant to this case. And really, but we're going to pull it up here. Let's take a look. Give me a moment here. Let me drop it in. So we've got the main case that she was talking about was Commonwealth versus Elvin Valentine. So I've got it up here. So let's take a look at this case. All right. And Commonwealth, let me share this tab instead. Let's power up the Justice computer and take a look at it here. So there's the case. I hope it's coming through well enough for everyone to read. But here it is. So what it deals with is, at the trial, the judge erred in admitting evidence, photographs. Let's see here. Let's find the relevant portion of it. That's not the relevant portion. So defendant was convicted. Concluding background, Breck was treated at the hospital. So what they're talking about, and I was reading this case as they were talking, and this is what you should do. You're here to cite, search it. You can find the case right here. I've got the briefs, the supporting briefs, everything to fully understand the decision. So you can look this up and get these cases. But this is what you want to do, so you can read along. And I picked up on exactly what the prosecution was saying here, which is this deals with stating, it actually kind of turned against the defense, in the sense that the court held that he wasn't entitled, because it was a few hours before that the relationship ended, that they weren't entitled to get this instruction. Whereas in here, part of what they're relying on here, or what the defense is relying on here, is saying that, let's see here. Let's just go and look at the case here. Hold on a second. Let me find it here. Caution admits a firearm. That's not what we're talking about. Even if we agree, argues tending to show acquainted, improperly admitted evidence, however, did not create a substantial likelihood of Ms. Krasky's argument. Defense searched several aspects that were improper, lying in wait. That's not the part we're looking for. Okay, here it is. Jury instruction on voluntary manslaughter. At the close of the evidence, the defendant orally requested an instruction on voluntary manslaughter based on the theory that the defendant killed the victims in the heat of passion because he was reasonably provoked when he saw Beck with Diaz on the night of the shooting. Concluding that the evidence did not warrant a finding of reasonable provocation, the judge denied the request and the defendant objected. The defendant contends that the judge should have instructed the jury on voluntary manslaughter because the defendant still considered Beck to be his girlfriend at the time of the shooting. The defendant acknowledges that Beck had told him that their relationship was over and that she was dating other people, but points to his statement that he had warned her not to do it in his face. The defendant maintains that he went crazy when he saw Beck walking with Diaz, and thus that the instruction was warranted. Where an instruction on voluntary manslaughter is requested, a trial judge should so instruct the jury if any view of the evidence would warrant a finding that the unlawful killing arose not from malice, but from sudden passion induced by reasonable provocation, sudden combat, or excessive force in self-defense. See Commonwealth Acevedo. Now, I also looked up Acevedo, and Acevedo is where all of this originated from. Where you have what they now call an Acevedo issue, where you're in that case, it was in regard to excessive force in self-defense, but they basically said in that case that a defendant, if there is any view of the evidence that it's possible that you could see that the killing did not arise from malice, but from any of those three things, that an instruction is warranted that the jury is allowed to consider it. And in the Acevedo case, it went to the first time it went to the case or to the jury, the defense attorney in that case basically dropped the ball and didn't ask for an instruction stating the state basically asked for a jury instruction that stated that the only way they could find manslaughter is if they found self-defense. However, they were asking is there any other aspect that they could find? And they came back and the judge re-instructed the jury with the same instruction that they gave before. 40 minutes later, they convict the individual second degree unaliving. The issue is the jury was looking at the evidence and potentially finding there was reasonable provocation or, I think was what they were saying in that case, if my memory serves right from reading. I was just reading a few moments ago. But the prosecution had gotten an instruction in that basically said it was only self-defense. So it got reversed, and the appellate court found that the correct that if there's any view of the evidence, and it's got to, and in this case, it's got to be viewed in the light favorable to the defendant, because the presumption of innocence is in the favor of the defendant. If there's any way you can view the evidence that any of these three things have, then you're entitled to that instruction. And the jury is entitled to that full instruction. And that's what the court found. So that's called that's the Aceveda issue. Now, reasonable provocation means that a reasonable person would have been provoked to lose his self-control in the heat of passion, and that person would not have had time to cool off before the killing. See Commonwealth v. Acevedo. Because the standard is both objective and subjective, the jury must be able to infer from the evidence not only that a reasonable person would have been so provoked, but also that the defendant was in fact provoked and that he or she did not have sufficient time to cool off in the period that elapsed between the provocation and the homicide. That's Commonwealth v. Groom. We view the evidence in the light most favorable to the defendant to determine whether an instruction on reasonable provocation was warranted. That is from Acevedo. So that's what they were talking with the judge was about, and saying, well, because we have to view it in the most favorable light to the defendant, in this case, the fact that there was a separate Facebook page, that the defendant would have potentially, in his mind, still viewed this as an ongoing relationship. And then he goes in and views an actual sexual act going on, whereas in this case, it was simply them walking together holding hands. Not even a sexual act, that they're entitled in this case. Now, the judge clearly, as you could see in that argument, was not open or was trying to figure out a way to not give that instruction, and he's believing that he might have found a way to avoid it. The defense attorneys seem scared to death to sit there and call this judge out, because it seemed like they're not even, they weren't confident in this case, or at least in the facts of the case. And here's the thing. If they should have put on more of a case then to hammer in whatever it is that they need to do, or what they needed to do in this case, they should have made sure that they addressed that issue. What they were trying to address, I think, in the video of that car, which was the only evidence they put on, was trying to show that it was a 3-minute ride and that they went directly to the house, and that the jury could then infer that this thing, he finds them in the car, they drive to the house, crime happens, it's all part of one event. It's all in the heat of passion, and the provocation being he sees her having sex with another man. They get back to the house, they're arguing about it, that the argument never stops. They get back to the house, and in that argument about what he just witnessed, he stabs her. Now, the thing is, this is where the defense attorneys, I don't know what they're doing, because to me, what they should have been pounding home was the idea that she was provoking him all night. That she's telling him at the house, that he's saying, she knows he's there. And that's what they should have really honed in on, was she was aware of his presence and continued on acting in a provoking way, knowing he was there, knowing he had asked her, knowing, that's the argument that you make. That's the idea that she knew they were in a relationship. She was trying to upset him. She was trying to be provoking. And would you see a reasonable person? Now, the judge was referring to say, well, he chases her down. He didn't have to be there. He chose to be there and put himself in that situation to be provoked. This was not where he just happens upon this in a parking lot because he's walking down the street and sees two people fornicating in a truck and goes, "Oh my God, that's my ex-girlfriend, or that's the mother of my child. What are you doing? Get out of the car. Come on, you're coming with me." And it goes on. I understand that's not what happened here. He was in there. He was coming in to see. She was going out. he couldn't handle it. He's telling her he couldn't handle it. So the idea here is, why did she lean into that? What was she doing? It seems like to me the entire night was about provoking him. The questions I would have asked of her cousin is, was this normal behavior for her? Does she normally go out and sleep with men like this on the first night? Is this normal behavior that we would expect? Or did you get, or is this behavior that she was wanting to go out and provoke him and let him know this, essentially, I want to piss him off. I want to hurt him. I want to get him upset. And the defense didn't delve into that because they leaned into the idea, the state has to prove it. But if they don't get this instruction, then the best case scenario they're going to get is second degree. And that's not good, because this judge can still give him a life sentence. They could still give him 50 years to life. And you already heard the judge say 28 times. He stabbed her 28 times. So you want a cap, because this judge is going to give him 20 years. But I got a feeling what this judge would do if he sentenced him, he'd give him a year for each stabbing, and he would get 28 years to life. So this young man will be, his life is over with in terms of having any type of life. But anyways, this is what we have here. So let's continue reading this here. Here are the evidence introduced at trial. Here the evidence introduced at trial would not have permitted the jury to find reasonable provocation. Even assuming that the defendant still believed that Brecht was his girlfriend on the day of the shooting, the facts do not support a finding of reasonable provocation as defined in our case law. Viewed in the light most favorable to the defendant, he and Brecht had been involved in an occasional romantic relationship, which Brecht had ended several hours prior to the shooting. That's the aspect that the state says is compelling. But listen, there's more here that I think the defense attorney should have really honed in on. Moreover, on the night before the shootings, Brecht had rebuffed the defendant when he tried to visit her at the hospital. The defendant thus had no reason to expect that Brecht would not become romantically involved with other people, and has no basis upon which to claim that he was reasonably provoked when he saw Brecht with Diaz. See Commonwealth v. Benson. Provocation occurs only when an action of the victim triggers a sudden loss of self-control in the defendant. This is why that they should have been honing in on that, and they should have had that case right there, which is Benson, okay? Because what you would have been arguing to this judge is saying, listen, her actions the entire night were meant to trigger him, and then you get the instruction. So why did they not do that? Why would they not have, and again, I don't have their memo, but if they don't have Benson in there, it's a 2009 case. And in contrast, Commonwealth v. Andrade, evidence supported inference that the defendant observed spouse with another man, thus confirming his suspicion of unfaithfulness. Even were we to assume that the defendant reasonably could have expected fidelity from Brecht, the evidence would not have permitted the jury to find that the defendant was reasonably provoked. The defendant did not come upon Brecht and Diaz engaged in romantic or sexual activity. Okay, and that's where the defense is saying that they carved this out and said because of the sexual activity, that this case gets to be, they get that instruction. That's why they're citing this case. The judge is trying to make a carve out now of saying, well, it says come upon, right? Meaning he didn't bring it on himself. He just comes upon us. Now, obviously, most of the time, if you're suspecting of things, you're following your spouse around, you're following your person around, you're following this individual around because you think that they're up to something, right? So coming upon it is I think the judge trying to make that carve out there. I don't, again, maybe there's other cases out there. I don't know because I'm just simply doing some quick research here. But he observed them merely walking together towards her apartment. Compare Commonwealth v. Smith, where the defendant discovered the victim, whom he had been dating for 6 weeks, engaging in oral sex with another man. On these facts, the jury could not infer that a reasonable person would have become sufficiently provoked to shoot and kill two people. There was no error in the denial of the defendant's request for a manslaughter instruction. So what they used this case for was to say that the appellate court says if it would have been these facts, we would give that instruction. I don't understand how the judge can say in this case that you would look at this where even though they had been talking about the end, they're living together, they share a child together, she's aware of his presence, she's going out and still going to go sleep with the man in the parking lot at the bar. Is that normal for her? I'm not saying there's anything wrong with that necessarily in general, but I'm saying in that particular instance, if she doesn't normally do things like that, and she's doing it, and she knows he's in that bar, and she knows he's going to come upon this, why? What was the purpose of it? Was the purpose clearly was to trigger him? So what the heck were these defense attorneys just arguing? And why were they not making that argument? I mean, I can't understand it. That to me is just ridiculous. They should have been making that argument. But anyways, that's what we're dealing with here. Tomorrow or tonight, I guess, the attorneys will be made aware of whether or not they're going to get the manslaughter instruction or not. It looks like we're also asking to get it through the an instruction of mental incapacitation because of the fact he attempted to unalive himself. And then on top of that, there was evidence that he had been drinking at least at some point in the night. So they could say that the drinking, and there was another case that's loosely cited, that was Gray versus Commonwealth. Hold on here. We'll share this tab here. Gray versus Commonwealth. And let's take a look at that case. So Gray versus Commonwealth, is that coming in good? Yes, it is. All right. So Gray versus Commonwealth deals with that the let's look at this here. So it talks about here's the part that's specific here. So evidence tending to show the admission and evidence of the defense medical condition is appropriate because it bears question on whether the crime of unaliving was committed at all. Just as we permit evidence of a defendant's alleged intoxication to be considered when his specific intent to kill is in issue, that's Commonwealth versus Henson, we should permit the jury to consider evidence of mental impairment at the time of the crime in deciding whether Commonwealth has proved the defendant's specific intent. Indeed, consideration of the effect of a mental impairment for which a defendant is not responsible seems at least warranted, as our present practice permitting consideration of the effects of the voluntary injection of drugs. The exclusion of such evidence could raise a constitutional problem because an absolute rule that bars consideration of relevant evidence bearing on a defendant's capacity to have specific intent is, in any event, arbitrary. Commonwealth v. Henson. We have suggested that if a defendant's mental impairment affected his capacity to form specific intent or to do grievous bodily harm, the defendant would be entitled to an instruction on the effect of his impairment on the question of malice. We therefore conclude that the judge's failure to instruct the jury on the issue of intent that they should consider the defendant's mental state on the day in question requires reversal. So, if there was evidence tending to show that because of his mental condition. So essentially what they're saying is he attempted to commit unaliving or unalive himself. Therefore, there was evidence that he was mentally impaired. He was mentally disturbed. On top of that, you have the alcohol. And specifically what they're saying is if alcohol doesn't mean you go unpunished, but it can remove the ability to formulate specific intent, which specific intent is required in order for malice to be present. You have to have a specific intent or desire to kill somebody. And when you're drunk, the state of Massachusetts holds that is a defense. It doesn't get you completely off. It gets you up to 20 years, but it's something that if you could say there was provocation and you were intoxicated, and in this case, again, the defense, why would we not put on evidence then that he was drinking? Again, this is why I said in his case, it was a case that he needed to testify in, but again, the burden is on the state. But I think if he would have testified, the defense that testimony becomes evidence, and as a result, the judge would be required to give these instructions. And because the state or the judge is going to get away possibly with not giving an involuntary manslaughter instruction, although I believe there is enough evidence there that allows them to argue that to the jury, and that instruction should be there. Although I see all these other cases, I don't know what they presented in their briefs, but I felt like that attorney did not seem prepared for that judge, and that judge was basically saying, sway me and make the case, and I don't know. I felt like the judge was not indicating that he was going to go in their favor, but that's just my take on it. Anyways, that's where we stand on this, guys. It'll be interesting to see what happens. So tomorrow, it sounds like 9 a.m. closing arguments. Sounds like closing arguments are going to take an hour and a half, and the case will be to the jury by 11. And then we will have a verdict in this case as he said, they don't go past 4 o'clock with deliberations. So if they don't have a verdict by 4 o'clock, it'll move into Thursday. And I could see a case like this going into an extended deliberation if this is if that voluntary manslaughter instruction is available. I believe, though, what I believe is going to happen in this case is I think that it will end up being a second degree. That's what I think. I don't think they're going to go first. I think there's enough here with the facts and circumstances that it will be a second degree unaliving. I think that's just where this jury is going to fall. I think that's where this should have been plea bargained to in the beginning. I don't think they're going to get first out of this. I think that given the facts, sets of circumstances, now it's potential that I think it'll be a quick deliberation. Everyone will fall to second, and it'll be done in 2 hours if there is not an involuntary, or if there's not a voluntary manslaughter instruction. If there's a voluntary manslaughter instruction, this could be extended deliberations for the simple fact that there may be some people back there that say, hey, I can understand that. That is a strong case. But if they're not allowed to consider that, if they're not allowed to consider heat of passion, I think this very easily falls second degree. And I think we'll have a verdict by, I don't know. They'll probably eat lunch. They'll get their state funded lunch, probably have a verdict by 2 o'clock tomorrow, and this case will be concluded. And then we get to make the decision of whether or not we're going to go back and cover the original case I was going to, which we're only 1 day behind on, where we're 2 days behind on, and we will go into ultra catch-up mode on that case and just jump right back into that and see what, and start covering the Rancher case out of Arizona, since this case only took 2 days to get done. I'm glad we covered it. It's a great, interesting case. But that's what we'll do there, and probably just start catching up on that tomorrow. We'll catch closing arguments tomorrow, and then maybe I'll switch gears, jump into the Rancher case, and then we'll do the verdict whenever it comes up. I'll keep monitoring it on a side screen and go from there. So anyways, guys, with that said, we're concluding today's testimony, the PM session. Let me know in the comments, where do you think this case is going to be at? Do you think it's a first, second, or manslaughter? Let me know your thoughts. And I'm going to try to do Justice Watch Live tonight. There's a lot to talk about right now. We've got the Diddy situation going on. I want to talk about that. We still got the statement that got suppressed from the father out in Ohio that we need to talk about. We've got this case. We've got, strikes me, there's a couple of other things I want to discuss. Also, too, check out tonight, starting at 7 o'clock, Trial Watch. Evening Trial Watch is going on now. It's not going to be run through the normal courtroom, because these are going to be old cases that we're going to put on stream. For those of you that want to watch a case at night, I'm going to be profiling these cases. The case that we've got coming up is one that we just watched an interrogation video on Sunday night. It's the mom out in Ohio, the Giagas child case, where a mom abandoned this child, left this little baby, this newly born baby, in the woods. The body was discovered, and for like 27 years, nobody knew who the mom was. She uploads her DNA to a one of those genealogical sites, and we saw the interrogation. She confesses to the police. Now she's about to have a trial, okay, and she's facing life in prison. Can you imagine walking around with it? She got away with this for 20 plus years. Now, mother of 3, successful individual, married the man that she had that child with, who had no idea that child existed, and now she's facing trial. That trial will be airing tonight through Sunday night as we air the entirety of that trial. It's one that wasn't covered on Law and Crime. It's not covered. It wasn't covered by many news outlets. So check it out tonight. We will be watching it. I won't be in the box on that one, because that's not the format of those trials. This will just be watching together in chat and chatting it up. And I'll be watching with you as we watch this. And then, of course, Justice Watch Live will go on once that first night of that's done. I'm not going to run it at the same time, because I want people to be able to watch that. And then after that, we'll do hopefully some Justice Watch Live after we get done watching that case. So that starts at 7 o'clock, 45 minutes from now, guys. We've got trial content. We've got court content. We've got everything going on constantly. But Justice Watch Live, we're going to take on some of the biggest things going on right now in the in the justice system right now. Also, we're talking about, if anybody wants to talk about anything from the gagged, why they silenced Franklin Tucker, we'll talk about that too. Come with your questions. Justice Watch Live is about interacting, talking, and really breaking down these cases. Anyways, with that said, guys, we're going to end this thing till we talk again. Let justice prevail, and I'll talk to you soon.
Took a swing at a wrecking ball and I prayed for my downfall, and I found a way to reconcile, 'cause in my heart it's not worthwhile. It's a bloody battlefield where some go down, others heal. In the end it's all the same. All you can do is play the game. Oh, do we say goodbye?